So welcome everyone to the next session here at the Berkeley Center of Law and Technology for our NIL series. Once again, Ksenia Maiorova has generously donated time to help curate this panel and then run the fireside chat portion of it. Those of you that have seen the other ones, you know the introduction on this. Ksenia has been kind of a leader in this space, both intellectually and I think on the human side of making sure students and student athletes have good knowledge and a fair chance to understand what their futures are going to look like under the NIL regimes, and then the potential competition between university knowledge and advice and the real world legal problems that could pop up. So, Ksenia, once again, thank you for joining us. We really appreciate this, and I'll turn it over to you.
Thank you. Thank you so much. All right, so today is Model 4, and we are going to be focusing on the advocacy component of the intersection of NIL and immigration. And I couldn't have brought better people into this conversation than people who have actually been involved in those advocacy efforts very intimately and very directly. And today we're going to kind of chat about some of the ways in which we might be able to fix the NIL and immigration problem. I think, the direction of our conversation will take a slightly different tone now that presidential election results are in, and we do expect that the tone of the next administration will, to some extent, affect our options going forward. But I want to start by just kind of talking about the bigger issue here, and that is, the different tools that we have at our disposal in terms of fixing this problem, right? So how do we fix the law, and what are the mechanisms through which the law might be fixed? And so I think that it's fair to say that we kind of have three levels of fixes. The most durable and, in our opinion, the most favorable of which is a statutory fix. However, that fix requires a certain amount of congressional agreement on immigration issues, and I think that the panelists and I are in agreement that we probably don't have that level of buy-in from a bipartisan standpoint to be able to push legislation forward to actually amend the Immigration and Nationality Act and create a new visa classification or some other mechanism through that amendment that would provide a direct path to employment authorization for our NIL athletes and for the athletes that are now going to be affected by the House settlement. The second level is going to be a regulatory fix. And so a regulatory fix is going to require the administration to publish some proposed rules, to seek comment from the public on those rules, and to then decide whether or not they want to adopt those rules. I'll let my panelists speak to their opinions on these, but my take on it is, we had perhaps a chance to do a regulatory change if the Harris administration took over. We would have considered that kind of a friendly handover, but I don't perceive the Trump administration as prioritizing this issue enough. Perhaps I'm wrong. I'm going to ask David and Amy to offer their opinions on this. And the last and least durable option is going to be a policy fix. And the reason why it's the least durable is because it's the easiest to rescind. And we already know from some of the chatter about the Trump takeover in January and their plans for immigration is one of the things that they intend to do on day one, or at least very soon after taking power, is to rescind all Biden-era policy memoranda. And so again, we would have to get a level of political buy-in from this new administration to perhaps convince them that a policy memorandum is something that they want to issue in this regard. And I'll start the conversation with Professor David Weber. He is at Creighton University. He studies this intersection of of NIL and immigration and has done so for quite some time. I always love to speak to him because he kind of sees this from a different standpoint than Amy and I. Amy and I always have our industry side glasses. David is the measured academic among us. So just your thoughts on, sort of these three options and and whether we see any future in any of those menu options for us going forward with the Trump administration.
Sure. Thanks, Ksenia. I think it's a really interesting topic. Obviously, we've been in the weeds on this for quite some time. We've seen some pieces of legislation proposed that would have had some fixes. They didn't get very far. And I think the general consensus is more or less that the liberal side of Congress has been more pro-athlete in terms of athlete-friendly fixes, whereas I think the conservative side has been seen as more perhaps NCAA or conference or university friendly. And I think it'll be really interesting to see what happens when we get to next May. And I think the NCAA has been pretty clear so far that whether or not that House settlement is given final approval, they're moving forward planning on those same components being part of what they're going to roll out next year. A big sense of what I have of how this has played out so far is that immigration really hasn't wanted to, or Department of Homeland Security hasn't really wanted to jump into the fray. They wanted to let things settle out a little bit because nobody really knew where we were going to go with NIL payments, with employee status. And I think next May, we might get to the first time where the rubber hits the road. And so then there might be a little bit more incentive for something to move forward. I've already heard from a couple of people on the Hill who are tentatively looking at new legislation plans going forward. And I think it's always risky to tie your hopes to that kind of legislative fix. But I do think that the House payments, once we see direct compensation from the universities, I think that might then at least provide some incentive to immigration, to DHS, to maybe take a more active role in perhaps doing the regulatory fix, which I think that they could still do. And I think that there still would be some bipartisan approach, especially if it is a standalone issue, where it's not all wrapped up into perhaps like an antitrust exemption for the NCAA. So I think there is that possibility moving forward. I don't know, based on what I've heard so far, early days, about what the new administration is planning. I don't know that we're likely to see an interpretation or a policy-based fix come before a regulation-based fix. I just think that there are so many different priorities that are being juggled. I worry that once again, that these student athletes, being the international ones, being a relatively small portion of the overall NCAA athlete population, they run the potential risk of falling through the cracks yet again because their problem isn't large enough to touch on enough individuals. Now, I do think that as college sports continue to take off and you start to see more schools with a significant international athlete component, that you start to create a wider constituency to have interest in this problem. But if you're asking me to rank sort of what I think as likely outcomes, I might say a regulatory fix first, potentially followed by a standalone piece of legislation, followed by an interpretation, followed by more comprehensive legislation. I think it'll be really interesting when we see two things happen. One, when we see the direct payments starting to come to universities from NIL, and then two, whatever happens with the employee status of athletes. And if these college athletes are deemed to be employees, I think that is going to force action much more quickly than the House current NIL component will.
Yeah, that makes great sense. Do you think some of the reluctance on Capitol Hill is part of a broader perceived reluctance on Capitol Hill about promulgating any sort of federal legislation on NIL? I think that, generally the consensus in the industry is that Congress does not want to promulgate federal regulation, and they sort of want this to be handled at a state level. But this particular issue, because of the way that immigration law works and that it is only federal due to the plenary doctrine, we require a federal fix for anything to happen. The states cannot fix this in their own individual capacity. Can you kind of speak to that?
Sure. And I think the NCAA is also very interested in a federal approach, right? I think if they had their preference, that is absolutely what would happen. On the immigration side of things, that absolutely makes the most sense, just because states aren't able to legislate around it. They're not able to be those laboratories of democracy because it's a federal issue. So they have zero latitude. The NCAA would love to see an equal playing field. Whatever that playing field is, I think that they would like to see schools bound by the same rules of competition so that, states like Missouri, where they passed a law that says athletes in high school can make NIL as long as they have declared and decided to go to a Missouri-based university. So you see states, for obvious reasons, wanting to gain a recruiting advantage, and they're doing all these little different things, and that's really affecting the national landscape about competitiveness and what we're trying to do. And I think that equity, that fairness of a national landscape plays very well with the immigration component because one, they're international, so it is that visa status. But I think we also want to be cautious about creating that second class of student or student athlete, college athlete, where they're not able to capitalize on many or almost zero of the opportunities available to their domestic-based counterparts. And I think what happens is if that problem isn't solved, where the NCAA and college athletes have really been, or college athletics has been benefiting dramatically from this influx of foreign athletes, that will dry up, right? Because the incentive is that they can come here, they can compete, they get good showcasing for professional sports. And for now, during the NIL era, they can still get compensated for that. I think we started to see more athletes coming at higher levels of competition and ability because they can get that NIL compensation. If they're precluded from any compensation because of visa issues, they're simply going to stay in their domestic leagues, right? And I think that will be a loss overall, not just for college athletics in the United States, but potentially even professional athletics.
Thank you. And Amy, similar question to you, but sort of from your industry perspective, where do you see this landing? Where do you see these advocacy efforts going forward? And how does the fact that the concentration of money, at least under the House settlement, being more aligned with football and basketball kind of affect this issue, whereas I think the majority of that representation of international student athletes across NCAA sports is not in those two sports. And you kind of speak to those tensions and dynamics there.
So I think, first of all, I'm very skeptical that we're going to get any kind of legislative solution. It's possible, but just with the makeup of the incoming administration's team being, Stephen Miller as the big point person on immigration, we know that he's not a fan of any type of immigration. And I don't see that as a reality. I think there will be a way to market, and I think that's a really important word because I think that is where the Democrats have failed traditionally. But to market this to the administration through Republican senators in red states who are very attached to, let's say, their Alabama football program. Sorry, Ksenia, I know you are a Tennessee fan. So I do think there's a policy fix that we can get through if we approach it strategically. And but I don't see anything. Yeah, I don't see anything going through Congress. And honestly, I don't know that we're going to get a regulatory fix for at least a couple of years. I think we're going to have to cycle through this big deportation push before we can get anybody's attention back on this issue, which is unfortunate because we've been trying to raise awareness about this literally since 2021, and it just has not gone anywhere. And in terms of the tensions, I mean, I think obviously there is some unhappiness from sports that are less marketable than football and basketball in terms of how much people are going to be compensated. And it doesn't seem like the settlement itself gives clear guidance on that, like who gets what, where, and when. So that makes it kind of a Wild West free-for-all, which is probably not the best way to handle this. But what do we know? We've just been trying to get somebody's attention on this issue for years.
Yeah, so Amy, you mentioned a statutory fix and that you don't think that it will go anywhere, but I think for the benefit of the audience and just kind of exploring things in a very theoretical realm, can you speak to the efforts that the three of us were involved in with Chris Murphy's office
Sure.
to actually pass legislation that would fix this, and the mechanism that we selected to do it?
Yeah, so I mean, as you know, obviously, because you and David and I were all involved in this, we worked with Senator Chris Murphy's office on one of the only NIL bills, and I think there were definitely more than 10. I want to say there were like 16 plus proposed bills that would address NIL, and Senator Murphy's bill was the only one that would have actually solved this particular issue for international student athletes. And I don't remember what we proposed as the fix, Ksenia. You'll have to remind me. I know it died and didn't go anywhere.
David, do you want to take that one?
Sure. Well, what we were looking at was creating sort of that subcategory under the F1 visa class. So we could call it like an F1A for F1 athlete.
And they would be,
and they would have the statutory authority to engage in work just due to their status.
Right.
yeah, I mean, I think that's optimal. Although we did get some pushback because we were also involved in other advocacy groups prior to that. So we were, talking to an organization that had a bunch of coaches associations that were participating, and they really wanted to focus only on NIL for athletes. And then we spoke to athletic compliance directors at universities or associate directors who said we can't justify supporting this only for athletes and not for influencers and not for other constituencies at the university level. So it is interesting to see how we couldn't even get agreement in a pretty small group of advocates about the same thing. I don't see, I know that we've seen, for example, Senator Ted Cruz's office come out against any payments to athletes whatsoever. So they're very adamantly against this. I don't see consensus, and maybe this is something that could be a bipartisan issue. But we also heard some silliness. I can't remember who said this, but we got some feedback that the United States should not be training the athletes of competing countries who will be our opponents in the Olympics. I mean, I don't even know what to do with that.
That was in the televised broad NIL hearings.
Right.
And it was someone from Texas, but not Ted Cruz.
Yeah. I mean, there is definitely not consensus about how to handle this period. I think employment lawyers have been kind of ahead of the curve on calling this from the very beginning, saying this is going to be employment. And I was swayed in the past couple years, but originally I thought, oh, we should make it an exemption from employment, and that's just not going to work.
Yeah, so go ahead, David.
It can get even messier, I think, because in the Johnson case, when they're talking about the economic realities test for whether or not an athlete would be an employee or not, the court had made some remarks about, whether or not they're an employee might depend on which sport they're playing. And so if now some athletes are employees, some athletes aren't, but they're all on an F visa, and then or they all can't work, I think it can even get more complicated going down that path if we're trying to slice up which of the Division I athletes are employees versus not. And I think it's going to get messier before it gets cleaner in that sense.
So just to clarify, what was sort of the rationale for making that distinction between different sports? Can you tell us about that?
I don't believe the rationale, but the rationale really came down to which sports were profitable. And the reason I don't buy that is if you go to work for a nonprofit or you go to work for a Fortune 500, either way, you're doing work, right? In one case, you might be generating profit. In the other case, you're not, but what you're doing is the same. And so if you're putting in the same amount of hours with the same amount of controls that the coaches have over you in terms of when and where to practice, sometimes even what to study, all the travel stuff, I think that gets to be a very difficult decision-making process. And now we're going to have potentially a third circuit deciding which of these college athletes are employees or are not. And so I think there's just so many unintended consequences that we haven't even uncovered yet.
That's really interesting. And I do find that when I speak to folks in collegiate compliance, they do seem to really want to make this demarcation between revenue and non-revenue sports very clear for their own internal compliance reasons. But I also feel like, now there's also a tension between this idea of independent contractors and employees, right? And I've had some conversations with a few folks in compliance over the last few weeks. And what I'm seeing is, from at least the university perspective, is I think that there is a broad understanding that the classification of these athletes as employees is coming. I think everyone buys into that. I think there's some disagreement as to the timeline and mechanism for that. And in terms of just their own compliance priorities, my sense is that universities are trying to kick that can down the road as long as possible. So more or less everyone that I've spoken to so far has articulated that their intention to handle the house payments, the direct payments under the house settlement, will be through what they will consider to be independent contractor agreements. And that, I think, they're hoping two birds, one stone. I think they're hoping that by classifying them as independent contractors and not as employees, they will also prevent themselves from running afoul of immigration law. And that's just not true, right? Because we know that the universities still have an obligation to verify that these folks that they're engaging as 1099 independent contractors are authorized to work in the US. And just because they're independent contractors does not mean that they are not employees requiring employment authorization within sort of the meaning of immigration law. And this tension is really interesting to me, because it seems that the way to solve it for immigration purposes is to try to put everything under one bucket and already handle it as if it's employment, right? Whereas the schools really don't want to go there quite yet, because I'm sure of unionization issues, insurance issues, other compliance issues that will arise as a result of that classification. So I'm wondering, David, if you have any thoughts on that, what your conversations with compliance departments have been like, and what are your general thoughts on the way to take this forward in a way that makes everybody happy?
That's a lot, but yes, I have comments on all of that. On the one hand, when I talk to compliance departments, and sometimes I'll reach out to the international student office at the universities as well. And in many cases, the international student office is not even thinking about this. It hasn't been brought to their attention. They've not even known that this was supposed to be on their radar. So they're trying to now get caught up as they're going forward. In compliance departments, you now have job postings for individuals whose sole job is going to be deciding how to allocate those direct NIL payments, 20 to 22 million per year. And I think you're right. If they're independent contractors, that's certainly easier for the university and for the NCAA to say, well, it's not an employee issue whatsoever. But if they're engaged in labor and the university is aware that they are in fact on F1s, that could be problematic. Now, if you're going to try to get clever with it, I suppose that you say, well, we'll pay you for your NIL, us, the university, you, the athletes, and we'll only pay you for rights, maybe of photos that we've taken at practice or at games. So they're not requiring the athlete to do anything beyond already participating. But that only works as long as the fiction that they're independent contractors holds. And so if that fiction goes away and they are in fact deemed employees, well, now the whole house of cards, at least for the international athletes, comes tumbling down, right? And so I think the NCAA for the longest time was trying to avoid any types of payments. And now it seems like they've settled into begrudgingly accepting NIL as not being pay for play, even though when you see how these payments are going to be allocated, it's going to bear a strong correlation to how talented the athlete is, especially in money generating sports. And so as they're looking at how all of this is going to shake out, I think the NCAA would rather just have a time machine and go back 20 years and say, gosh, weren't those the good old days? And unfortunately, they're being pushed, and they're going to have to face, I think, a very real reckoning, probably within the next year. And then it's going to depend on whether or not we have employment status, or whether or not courts and or legislators are willing to go along with the independent contractor label.
And so to some extent, doesn't that depend on the wording of these agreements between the university and the athletes that are expected to receive payments? And we've heard that the Big 12 already has a draft agreement circulated internally. I've spoken to some schools that are working on it outside of the Big 12 on something similar. So I think, the wheels are turning. The compliance folks are thinking about at least, setting up these agreements. But I wonder to what extent they understand the importance of, as David put it, maintaining this fiction that this is not pay for play, and not inadvertently inserting language into these agreements, right? That could be considered by USCIS to still designate that they are, in fact, just being compensated for the fact that they are on a basketball or football roster at University X, right? And so I think that it's really difficult to classify, in my opinion, and I'd love to hear from all of you. Amy, you're next, and Jonathan, I'm going to ask you after Amy, but to what extent do you think immigration is going to buy this fiction? We've got $20 to $22 million that are going to be given to a school to split up as they wish. Our understanding for the time being is that we anticipate that the bulk of that money, if not all of that money, is going to be distributed between men's and women's basketball and football. And then, to some extent, we're seeing indicators that the amount of money that an athlete will receive will be correlated to, their value as a player, potentially, on the field or on the court, as the case may be. And so with that formulation, with that understanding, does artful language save us from this idea that this is, in fact, what we all pretty much understand that it is, and that is pay for play? And Amy, just your thoughts on that.
I mean, I think that it doesn't necessarily, I think the devil is going to be in the details. How are they going to calculate value? For example, I represent a couple athletes who are possibly better known than they are accomplished in their sport. One of them is an incredibly gorgeous female golfer from Germany. And the other one is, as we published in our prior book, Hansel Emmanuel, who has not been doing, stellar in terms of his NCAA D1 playing, but is an inspirational figure globally, has millions of followers on social media, is marketable in ways that, other athletes who may be better at playing basketball are not. Then you've got, what are they actually getting paid for? Like, what are the individuals doing? Is this set up as some kind of, the university is going to market all this stuff and they get, quote unquote, what people like to call passive payments where they don't have to do anything? Or are they going to be required to go to photo shoots? Or, I think that's where we're going to get into trouble with the government. What are they being paid for? What are they doing to get that money? Is that something that would normally be compensated? I think there are going to be some fairness issues, but yeah, I think the answer is we don't know. We don't know.
And introducing Jonathan Grode, my partner at Green and Spiegel, who's joining us to give us his thoughts on this issue.
I think it's going to be excuse my language. I think it's going to be a righteous shitstorm that nobody is actually really giving it any thought or proper contemplation. I think I'm going on year 2 now of trying to work with state to convince them to expand or amend 22 CFR 62.23 about what student athletes are and the student definition under J1. I've also floated the idea of listing student athletes as specialists and extending that duration under 62.26. Interestingly enough, on Thursday, Dan Mickelson, who's the sports diplomacy liaison for state, he's going to be in Philly. He's invited me to go along with him to the World Cup planning meeting that afternoon. And in turn, I'm taking him to meet the Flyers and the Sixers. And I'm going to spend 3 hours driving him around just talking about nothing but this to get them to actually look at it. Well, 2 years ago when I felt like I had a real appetite and real direction to make this happen, it's no accident that I heard that the Department of State retirement calculator crashed last Wednesday. Like there is a lot of change in the wind. So I think, and I fundamentally believe J1 is like the solution to this issue. I think it is the easiest way. I think they have the most flexibility. And I'm going to continue to push on, but the results of last week, I think, make it harder and more unlikely than before.
But
And,
what are your thoughts if the status quo remains, right? So there is no J1, there's no other NIL solution. We are left with the landscape we currently have, and then we have universities that are, essentially trying to play semantics with this idea of these are independent contractors. This is passive income. They're assigning the value of their NIL to our university, and therefore it's not employment. It doesn't require employment authorization. What's your take on whether that flies with DHS or whatever
well, you're not going to
agency they're going to have?
I mean, look, I don't know if they're going to enforce it, but there's this whole thing going back to like the Walmart case about constructive knowledge of independent contractors and whether or not they have status to work. I mean, maybe it's going to be one of these things where they let it go because they don't have the another option, and like the administration is going to be focused on bigger things. But to me, I think you got two issues that come from that. One, I think it doesn't remove the university, in this case, the employer, of liability by any stretch of the imagination. And secondarily, you're like clocking all of these people up with unauthorized work. Unless you are going to do something like what you were saying, David, about really trying to frame it so it exists only on campus and how you like kind of split that baby. But if I had an international student and they said to me, Jonathan, should I take this NIL money from the university? I'm going to say, hell no. No. So, I mean, Amy, that's my kind of.
But even if they don't, right? If they remain on roster while the other kids are playing, we still have an issue.
Right. And that's what I was going to say, which is, it's the old unpaid internship. Is that how I get around not having work authorization? And the answer is no, because if a position is quote unquote normally compensated, they view that as employment. So if it's defined as employment for US individuals, if it is paid for US individuals, I don't see how we get out of it with that.
No. And you're going to get this question, well, how will they know? They know. That's like my favorite like thing. And this is definitely my standard answer is they know. Well, this is really one of those situations where they will know. They will know.
Right.
And I love Karen Woolman's quote on this, which is
it's Margaret Stock.
Oh, it is. Well, I've heard it from
Karen Woolman quoting Margaret Stock.
Sorry. Margaret Stock's quote is, the question is not how will they know, it's what will they do when they find out.
Yeah, right.
And they clearly are going to know. And then, of course, with the doctrine of consular non-reviewability, with recent Supreme Court cases really reinforcing that consulates can do whatever they want, if you've got an administration who, I mean, I hear Marco Rubio is going to be the incoming Secretary of State. He's not as anti-immigrant as some other, potential administration members, but it's going to be basically up to the consular officer, and you have no recourse if you're found to be working without authorization and they want your visa.
So, so I got like triple booked for this half an hour, so I got a dash. But thanks for giving me the conch shell, Ksenia. And look, I think this is important work, and I think we're just going to have to try to scream it louder. But I also think we're going to have like a mitigation plan for those that get caught up on it, because it is going to be, very real. So, cool. I'll catch you later.
Thank you. So I think where we've landed with this is that, at least from the perspective of lawyers, and it sounds like the perspective of academics, the idea of using magic language to mitigate this is at best problematic. I think that, there's tension here, because I think some of the ideas that arise with respect to this attempt to classify all of it as passive income has to do with the conflation of the concepts of passive income and labor between different federal agencies and different federal bodies of law, right? So we have the Department of Labor definition of labor. We have the IRS definition of what is considered labor and passive versus non-passive income. And then we have the immigration statute and its definition of the services and types of labor that require employment authorization. And one of the takeaways from all of this is that they don't cleanly align. And I think from the perspective of GCs and other folks in compliance, they are probably far more familiar and are relying more on the DOL and IRS interpretations than the immigration interpretations. But the immigration interpretations are obviously what are going to govern the immigration component of this. And so, I think for our listeners who are at specific athletic departments and are in compliance, the takeaway here is we need to be talking. Okay, we need to have a conversation between the legal community and the compliance communities within these institutions about what is the best way to frame this in a way that, is in a way that takes into account the immigration specific definitions here, that isn't going to inadvertently get the university into hot water, right? Because the consequences are pretty dire, right? And you get cut off from E-Verify, you have the potential of losing your federal funding. And so in some ways, to Amy's point about marketing, maybe we've been marketing the issue all wrong all along, right? Because I think when Amy and I first got involved in these advocacy efforts, we spoke about this from the perspective of the student athletes, from the perspective of the consequences to them of being potentially caught up in a situation where their status is deemed to be violated. But now when we add this component of direct payments, whether through House or through, the NCAA of their own volition or some other mechanism, we now have a second actor here. And that actor also has consequences under the rubric of the law as it exists today. And so while I think, we can talk about advocacy and we can talk about, what we would like to see in the future, all of that has become incredibly uncertain. And I think as this issue develops, then what we really need to think about is, okay, the advocacy is great and we hope that happens, but we need to operate within the reality that exists today. And we need to be very careful about how these agreements are structured, right? And whether the magic language is going to garner the buy-in from DHS and from DOS in terms of whether this is labor, right? If we are signing agreements only with certain sports, if those agreements are negotiated based on the value of the NIL, and again, how do we calculate that value? To Amy's point, we have people who have probably limited contributions on the field or on the court, but who have very valuable NIL from a different perspective. Is the university interested in that kind of NIL value? David, do you have any thoughts on that? I mean, is value for the university from somebody who is not a phenomenal performer athletically, but who is a gifted influencer and has the opportunity to, through their platform, promote the university's brand?
Right. So I think there's a couple of points there. The first, I think, is as part of the House settlement proposal, there's this component that the NCAA really doesn't like collectives and is trying to limit the role and influence of collectives in the NIL space. So much so that they're trying to include that fair market value caveat. And I think it's ironic that I work with collectives from power conferences all the way down to Division II. I would feel much more comfortable recommending an international athlete to get paid from a collective because you can structure that to be done safely outside in a third country than this potential money coming from the NCAA or from the House settlement, where now it's coming from the university directly and we don't know exactly what the quid pro quo is, right? So you have that very unique aspect where the collectives here are actually providing some safety and that right to payment to the athletes that the NCAA seems to not be as concerned about. As to the valuation question, I think that actually shows a little bit of I hesitate to use the word hypocrisy, but a little bit of the hypocrisy involved in the House settlement by calling these payments NIL payments. Because I'm fairly certain that if you ask the coaches when they're trying to assign value, like which athletes should get paid, they're not going to care how many followers that individual has. They're going to want to see, I need a strong safety who can fit this type of defensive coverage plan or scheme. So I don't think that they're going to necessarily look at the true NIL value that a third party would look at it, like with Gatorade or Coca-Cola or Nike, where they're trying to figure out, we're trying to grow our brand here. I think the incentives are misaligned in this case, right? Because the coaches want to win more so than they want to grow a brand.
And so that kind of brings us back to this point of, is it pay for play, right? So if we're talking about true NIL, then it doesn't necessarily matter where the value of NIL comes from, whether it's from that athlete being very good looking or being a compelling content creator, or from their athletic prowess on the field or on the court. Whereas if we're tying the amount of the compensation as expected to the projected athletic performance of a given athlete, then this becomes little more than a very transparent attempt to pay for the caliber of athlete that you want or that you can afford, right? And I wonder how that plays into, in a larger sense, into this idea that the money is expected to be split up primarily amongst the revenue generating sports, right? Versus the non-revenue generating sports. And if you think about it, I bet even if you took a school like Oregon, for example, and you looked at the roster across every sport, I bet your Olympic medals are primarily on the non-revenue sports side, right? So your objective sort of performance there internationally and in terms of, that value, but less valuable to the school. And just seems to me that this has to do a lot more with the commercial realities of collegiate sports, right? And where they attempt to go in terms of both revenue generation and their competitive edge. Is that your take on it, David?
Yeah, I think that's spot on, right? Because if it is true NIL that the NCAA is harping on, it should carry all of that as a component, right? It should matter whether or not you're on a Wheaties box or whether or not you're on national television or commercials, because that's all part of that right of publicity.
Mm-hmm.
And if it's just based on how well you're doing for a revenue generating sport, well, that's not true NIL.
Right. And that pokes holes in the argument that this is an independent contractor who is receiving funds for their this is passive income for NIL.
Right. It's just it's a disguised quid pro quo, a disguised pay for play.
Right. Very interesting. Amy, any thoughts, anything to add to that idea?
I think we already had a lot of uncertainty, and with the election results last week, it's like head over heels uncertainty. We really have no idea how the incoming administration is going to deal with this. You and I have discussed previously that the Trump administration was actually friendlier to athletes, professional athletes and amateur athletes who were performing at a really high level than the Biden administration. Because one of the things that the Biden administration did is they removed there was like a Trump memo about how professional sports is in the national interest. So I did feel like these types of issues maybe got a little bit more attention. And hopefully that will carry over into the new administration. I'm not holding my breath. So, but I do feel like our uncertainty has basically increased by a matter of exponential numbers. So we really don't know what's going to happen or what solution there may be. And honestly, no one in the government has seemed that interested in a solution. It's like we've been offering solutions to problems that the government does not appear to care about for several years, and we continue to do that and apparently still have no takers. So
yeah, but I think if we kind of, going back to, okay, what's next? if we assume that there's a lot of uncertainty as to what the government is going to do, I think, the institutions really need to be mindful of this issue and need to understand that the leverage to solve this issue primarily lies with them, right? We are three people, two practitioners and an academic who can scream to the rooftops about it, but I don't have the same level of access that the football coach from the University of Oregon does. I don't have the same level of access that athletes who are directly affected by this do. And so I think fundamentally, the conversation just needs to start in a different place than it has been happening. And for that to happen, I think the universities, and I'm hoping that this program can be one of the instruments to accomplish that, is they need to understand that they're at a bit of a dead end here with trying to reconcile this issue, that right now there's no clean fix, that there's no legal avenue to accomplish both the classification as independent contractors that they wish to have and employment authorization for their international athletes. And so that is something that I think gives them the platform to then go to their congressional representatives and senators and say, we need you to fix this, right? Or we need this to be brought up through the committees so that the Department of Homeland Security finally takes action on it. Because this is an issue about university compliance, right? And we kind of talked about the marketing and the narrative, right? And when we talk about NIL, and sort of classic NIL, the pre-house NIL, pre-direct payment NIL, I think one of the reasons why the Department of Homeland Security has been able to avoid this issue and has been able to avoid doing anything about this issue is they believe that there's a level of optionality here, right? That you can choose not to capitalize on the commercial value of your NIL. And that may very well be true. But when you are a part of a basketball roster at a certain university that is now going to be distributing direct payments, you are a part of a single unit. And even if you choose not to receive those payments, as we discussed, that doesn't necessarily get anyone off of the responsibility for violation of the employment authorization rules. So, this is not something that can be fixed by any way other than A, coming up with a solution and a proper avenue, or B, taking the risk with magic language in your agreements and hoping to God DHS or DOS doesn't come down with the hammer, or C, getting rid of all of your international student athletes on those rosters, which I'm sure nobody wants to do. So I think, that is the kind of doomsday takeaway. I've been famous for those in the speaking circuits lately. I'm sorry, I hate to be the bearer of bad news, but this is where we are. But but I think the upshot is that we're also in a position to advocate for something here if people realize what they're dealing with, and we need to get that messaging out there.
I agree. I wouldn't be surprised what might really move the needle forward if a decision comes down that athletes are employees and we're in the midst of March Madness, and all of a sudden you have all of these teams who are not putting on the bench their star basketball players who are international athletes. At that point in time, I think there would be enough collective attention to it where you might be able to gain some traction.
Yeah. And so I guess while we're on advocacy and we have a few minutes left, we can kind of speak to another form of advocacy that at least Amy and I have been involved in, and Professor Weber is aware of. And actually, one of his legal opinions was used as a part of the materials for this case. But I wanted to mention the case of last year, Poa, the LSU basketball player, who was denied her P1 visa. So this is a case that I filed right around March Madness. I think we have spoken before about the challenges of getting Ps approved, particularly for NCAA basketball. The Department of Homeland Security would come back with, a broad range of bases to deny, but the most persistent one of which had been that they don't believe that NCAA basketball is an internationally recognized level of performance. because we cited all of the revenue and broadcast statistics from March Madness for this year, particularly on the women's side of the tournament, we were able to overcome that, but POA was still denied for the rather disingenuous reason that they took the position that her NIL contract and her NIL opportunities under that contract did not have anything to do with her role as a basketball player at LSU. Were not related to the competitions in which she would participate as a part of her itinerary. Professor Weber is looking very, very disconcerted by that, as were we. And so now that case is in federal court, and we hope to have a decision on that at some point here in the near future. But but this kind of speaks to, again, yes, O's and P's might be an avenue where, I think that one of the conversations that the departments, the athletic departments need to be having right now is, as a preemptive measure, let's try to move everyone we think we can from those basketball and football rosters to O's and P's. But as the POA example demonstrates, this really isn't a measure that is 100% foolproof either. There's a lot of chaos and a lot of inconsistency in the adjudication of cases across the board at U.S. Citizenship and Immigration Services. And the POA's example is just one of those, in the sense that her petition was structured identically to other cases that we have gotten approved. And, these issues were not raised before. And I think, Professor Weber can take us through the rather ludicrous position that her NIL is not related to her status as an LSU athlete. What are your thoughts on that, Professor Weber?
Well, the reason I was making faces is because it goes against exactly what the NCAA is proposing in the House settlement, right? Where they're saying, well, what we're trying to do is compensate them for their NIL. And here she's saying, well, and it's based in large part on their athletic ability and their role in that team. And here she's in the same exact position, which seemingly is supported by the NCAA. And the government's the one taking the contrary position that, no, we simply can't tell where this is coming from, where this value is, whether it's because you're an athlete or these other alternative factors. I think they're just two inconsistent positions. I think NIL right now in college athletics is part and parcel of the entire athletic package of that individual. So to the extent that they have better numbers, irregardless of more followers or general beauty or exceptional circumstances, I think that athletic ability makes up the bulk of their NIL value right now in college sports. And so to say otherwise, it seems to me just disingenuous.
Right. So lots of uncertainty. And on that fine note, I think we will close with some final thoughts. Professor Weber, what's your top takeaway from the conversation that we've had today?
International college athletes are in a tight spot. And I think a big part of that being that tight spot is just the level of uncertainty that's still involved. And I think every person who's representing an athlete or a client would like to be able to give their client advice that they think you should definitely be able to rely on this. And I think, unfortunately, we're in a situation where it's very tough to do that right now. So my big takeaway is that we still lack so much certainty.
Amy?
I mean, I think my big takeaway is everyone who is an international student athlete and who is getting NIL is going to be at risk. I think the risk is greater with the incoming administration because there are definitely some immigration hardliners who don't want any expansion of immigration employment authorization for anyone. And they're staffing the embassies and the consulates. So I think the risk is a lot higher. And I honestly, I mean, what we've been wrestling with is how do you get the government to do something, right? And the answer is not very easily and not very well. So we saw a case out of the Obama era where the Obama Justice Department challenged the right of unaccompanied children in immigration deportation hearings to have counsel at the government's expense. And the Ninth Circuit said, well, yeah, that's a due process violation. And yeah, the government should do something about it, but we can't tell them what to do because we're the courts. I kind of feel like we're going to be in the same place. Like, there is going to be something actionable, because no matter how you slice it, international student athletes will be at risk one way or the other. How do you get a policy out of the incoming administration? I think the best strategy is going to be to go through red states and GOP senators and congressmen who are big fans of their home state schools. But in the interim, I'm advising my clients to be extremely risk averse, more so than normal. And Ksenia knows I'm very risk averse as an attorney. So I would say don't travel. Don't put yourself in any situation where you're applying for a visa at a consulate or embassy, and wait for the government to do something. And that, that's hard. I mean, it's difficult for people not to go home and see their families for years. It's going to place stress on those athletes and possibly affect their performance as well. So,
Yeah.
not great.
So I think, my kind of final thoughts are, with this level of uncertainty, as Amy said, we want to evaluate our risk tolerance and develop policies accordingly. I would advise every institution to look at their rosters to see who they can transition or attempt to transition to OSPs and EB1s now. I think that's a more durable solution than magic language in these agreements, because then you have explicit employment authorization. And, as a final thought, I would ask the stakeholders to be a little bit more vocal about this issue, because I think that's what it's going to take to move the needle in Congress.
I would like to see the NCAA be a leader on this issue, because I haven't seen them do anything. I mean, I don't know what's going on behind the scenes, but they certainly haven't done anything publicly. They've just kind of been like, well, we don't know, talk to a lawyer.
They said that they're a member-driven institution and they want the schools to first kind of articulate their desire for them to do something. So a lot of kicking the can down the road. But I think we're out of time. So thank you both so much. Thank you, Wayne. With that, any closing thoughts from you, Wayne?
Again, these things make me anxious every time I finish one. It's a rare thing to make me anxious as a retired trial lawyer, but I can feel for the students, and that's what I hope people remember, that these are students that are just trying to navigate a process, and this is their future. And uncertainty is not good for anything. So with that, thank you so much. I really appreciate it.
Thank you.
Thank you.